Good day, Crime Talk aficionados. Guess what? We have Lori Vallow pretending to be a lawyer representing herself. How did Luigi Mangione get his ghost gun? President-elect Trump gets his sentence of no sentence. Road rage. What do I say? Let it go. No charges for a man defending himself on the subway in New York. Somebody's getting smart. This day in legal history and our dumb criminal of the day. Let's talk about it.
Lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications of when we go live or put up new content. And yes, you can check us out on any of your favorite podcasting apps. Before we get to the show, though, remember, go to crimetalksearch.com, sign up for that background subscription service today. When you do, you can do as many background searches as your little heart desires, and you'll be able to get as much information about anyone here in the United States, well, that is basically publicly available. And the beautiful thing is you can get updates on it as well. And hey, if you want to do one search and you're done, you can do that. You can cancel. If you want to do a search a day for the rest of your life, you can do that. Go to crimetalksearch.com. You're going to be happy that you did. All right, let's go ahead and open the record for January 10th of 2025. Can you believe it's already, we're almost halfway through the month, ladies and gentlemen, of 2025. Where has the time gone? Oh, that's right. Scott's been in trial for the last several days. And we'll talk about that more on our live show next Tuesday night. Didn't go well. Crashed and burned. Not for lack of trying, I assure you. We tried, but we'll talk about it. All right, first on the docket, Lori Vallow pretending to be in court. Yes, she was back in court today because they had a status conference. Now, things get a little more difficult when the defendant is a pro se defendant, which means they're going to represent themselves. But really, is Lori Vallow representing herself? No. She has an investigator and she has advisory counsel. Advisory counsel was sitting next to Lori Vallow today and helping her out. And when the judge asked advisory counsel if there were pleadings that were sent in regards to this particular case, they're in Arizona, would she assist in getting that to Lori Vallow? And she agreed, although she said it's outside of the scope of my representation. So what does that really mean? Advisory counsel. It means different things. I've been advisory counsel in state cases, and I refuse to do those ever again. And normally what happens is the court will call up and say, we have somebody that wants to go as a pro se defendant. Would you be advisory counsel? And I say no, because it's not worth it. One, you're getting paid at the state expense, okay? And it could be months down the road. And that pro se client is going to be the biggest pain in the ass that you've ever had in your life. Let me take it from experience, okay? I'll tell you from experience. Because you're not just their attorney to be there to advise them on, hey, how do I get this piece of evidence into evidence at trial? You become a copy boy, you become an investigator, you become their secretary because they're in custody. Don't do it. Then you say, well, we'll get an investigator. Well, that investigator then becomes a gopher, legal secretary, copy person, investigator. It is a pain in the butt. Lori Vallow, and they did change the name of the pleading, so I guess we should be fair. It's now Lori Daybell, so it's going to be Lori Daybell, formerly known as Lori Vallow. But she'll always be Lori Vallow to me. So therefore, we're going to continue to call her Lori Vallow. Anyway, she's not on her own. She's not doing this totally pro se, but she may have sounded somewhat competent, but she was reading today from a motion that she had in regards to the discovery that she believes that she is entitled to. Now, her problem with the prosecution is that Lori Vallow says there's all this information that she wants. The prosecution says, A, it doesn't exist, or the judge says it's completely irrelevant, so what would be the meaning of it? And Lori Vallow, when asked, why do you want all the information as it relates to the extradition of this particular case? How is that relevant to whether you killed your now former husband, Charles Vallow? It's not, but she somehow thinks it goes to a conspiracy. The other thing that Lori Vallow is doing is that she is trying to ask for specific information, okay? Now, she states that she has received over 100,939 pages so far in discovery, and she is looking for the evidence of a conspiracy, okay? So this is where particularly people that don't necessarily understand the laws of conspiracy, they think, well, what is a conspiracy? A conspiracy is an agreement between two or more people to commit an illegal act. So Lori Vallow needs to get it through her skull that in that 109,000 pages of discovery, she's not going to find a contract that says conspiracy to commit Charles Vallow signed between herself and her brother, who's now deceased also, Alex Cox. It's simply not going to be there, okay? But that's what she's looking for, and that's what you can tell is she wants the evidence of a conspiracy. She wants a witness list that they're going to do to show the conspiracy. Well, like I said, a conspiracy is usually never written down. You have to infer it from the evidence, circumstantial evidence. Remember, circumstantial evidence is viewed as the same as direct evidence, right? What is the difference? Direct evidence is I look out the window, I see that it's snowing. I see it with my own eyes, direct evidence. Circumstantial evidence, I go to bed, there's no snow on the ground, but I wake up in the morning, I look out the window, and it has snowed, but it's not snowing. So, through circumstantial evidence, we can reasonably deduce that it snowed last night. I didn't see it, but there's snow on the ground, so therefore it must have snowed. Circumstantial and direct evidence are viewed as the same. That is really what you're going to find. A conspiracy can be proved by conduct, kind of a wink and a nod, so to speak. But the problem is that the government has to be able to show that. So Lori Vallow, she did her best. She got nothing out of today's proceeding. We're scheduled for a trial date in the homicide to begin in 76 days from now on March 31st. And obviously, Lori Vallow will be on trial for the death of her now deceased ex-husband, Charles Vallow, for allegedly conspiring. And then she also has the attempted murder charges in another case for her niece's ex-husband. That one will be decided if it goes to trial after the conspiracy to commit homicide. Why? Because if there's a conviction, more than likely the prosecution may not go forward on the less severe charges. We'll see. We'll see. Depends on what a crazy mess is created with a pro se defendant in a homicide case. Now, jumping back quickly to the advisory council. Don't do it. The last time I did advisory council, it was in federal court, and I'll tell you the story. It was it's a story, interesting story, I think. So I get a call from the federal courts. They said, "Hey, we have a guy that is in here. He's back. He represented himself pro se up to the United States Supreme Court and won." I'm like, okay, it was a true threats case. And so I say, sure, this could be interesting. Who knows where this is going? And I go to meet with the gentleman. He's like, yeah, I don't really need you, but, if you want to stick around, whatever. Okay, fine. And, my position is, at that point, I hadn't been to the Supreme Court. I certainly hadn't won. I was like, what do you need me for? It seems like you're doing pretty good on your own. He goes, nah, I may want you. So we get to go to trial, and in the federal system, you have to be prepared to step in at any moment. So if the client says, I'm out, you're in, you have to be ready to go. So we go to start the trial, and the client really wanted to do his own voir dire, wanted to be able to pick his own jury. And frankly, I'll be honest with you, he didn't do a bad job, but it was all about race and all this other stuff, and it really wasn't hitting any home runs. And anyway, we get done, we select a jury, and the client gets up and says, Your Honor, I want to have Scott take over from here. And the judge, he's a federal judge, but he was a state court judge. I've been in front of him many times, calls me to the bench, with the prosecutor, obviously. He's like, Scott, are you ready to go? How much time do you think you need? I'm like, give me about 10 minutes, Judge. We'll be ready to go. Anyway, it was a true threats case. We lost. A jury of his peers, after the Supreme Court said do the right instruction, still found him guilty. That case ultimately got appealed, but did not change any law But so, when I talk about true threats case, I know a lot about true threats cases. I've done a lot of them. Free speech, baby. We're all about it. All right. Enough of that. There's your pro se defendant story. Don't go pro se. I always tell everybody, whether you hire me or somebody else, do not represent yourself. Go in there, hire an attorney. How do you know if the prosecution can even prove the case or not? If you don't know, you just simply don't. So always get yourself an attorney. Anyway, we digress. Sorry about that. Next, Luigi Mangione. That's right, the alleged shooter. Luigi Mangione was able to build his murder weapon, allegedly, thanks to directions he obtained from a 3D black market operator that he found on the internet. Well, where else would he find it? Anyway, the crime has been celebrated by some people in the 3D printing gun circles, allegedly. Now, Mangione was said to have used a 3D printed ghost gun for the murder of United Healthcare CEO Brian Thompson, to which Luigi said not guilty. Now, according to gun rights groups, a organization called Defense Distributed, a rival group known as Catalog, which publishes designs for 3D printed guns and accessories online, provided the files and instructions Mangione needed to complete the weapon as well as his silencer. Now, Defense Distributed is currently in a lawsuit with Catalog, alleging them to have illegally trafficked digital firearms information that Defense Distributed handles legally. Now, the lawsuit labels Catalog as a full-fledged criminal racketeering enterprise, and the suit alleges that Catalog is a, quote, black market operator in the worst sense, achieving its illegal ends with dangerously illegal means of criminal wire fraud, money laundering, extortion, and even threatened murder, stealing businesses from Defense Distributed, the only firm serious enough to do the work legally, and distorted and otherwise thriving and compliance market in digital firearms information. Now, that lawsuit also claims that Catalog celebrated and promoted their supported role in Mangione's alleged act. Now, other experts say it shouldn't have been hard for the Ivy League educated Mangione, who already had a tech background, to use the online files to print his own gun. Now, a researcher for Small Arms Survey has stated that 3D printed weapons can be fabricated and assembled by individuals with little or no technical expertise. Now, 3D weapons have not yet supplanted factory-built weapons in criminal circles, but if and when they do, we will have to completely rethink our approach to small arms control, says that particular expert. Anyway, it's going to get interesting, ladies and gentlemen. As the technology improves, it's going to be easier and easier to do it. Now, Mangione is accused of using his ghost gun, a potentially untraceable weapon that can be assembled at home from scratch or through weapons parts kits. Now, as you know, Mangione was busted in Altoona, Pennsylvania at a McDonald's in a backpack that apparently had the ghost gun and the silencer. Now, according to police, both the weapons and silencer were made using a 3D printer plus readily available metal parts, leading to fears that these types of homemade weapons will be used more often in crimes. Now, in 2020, federal officials recovered more than 25,000 homemade guns, and earlier this year, President Biden established an emerging firearms threat task force with an executive order aiming to fight back against unregistered 3D printed guns. Now, guns similar to the ones Mangione is suspected of using in the crime are relatively cheap, with one site selling a 3D printer starting at about $300. This includes the blueprint for a .22 caliber pistol and a filament, the material that the printer needs to print the item. Now, along with several fake IDs, the ghost gun and silencer Mangione was busted with had a handwritten manifesto detailing his grievances against the healthcare insurance companies. Now, the manifesto reportedly stated it had to be done. These parasites had it coming. I don't want to cause any trauma, but it had to be done. Anyway, Mangione has been charged with first-degree murder, along with several other charges, including 2 counts of second-degree murder, one of which is charged as a killing in the act of terrorism. He's also facing weapons charges and possession of a forged instrument. This gets interesting, ladies and gentlemen. One of the things that, for example, in the federal case, if the state case doesn't go well, the federal case has to establish that these items traveled in interstate commerce, right? So when you have a gun case, let's say hypothetically, you have a client charged with possession of a firearm by a prohibited person, i.e. one's a felon and you can't get a gun. So prosecution, the government has to prove that that firearm was not made in the state where we are, say, for example, Colorado. They have to bring in an expert to say that gun was manufactured by Smith & Wesson, it was imported, or it was manufactured in, Connecticut and then shipped to Georgia and ultimately made its way here through interstate commerce. I know it sounds strange, but yes, that is the way it works. So where's the interstate nexus if there's a ghost gun? Interesting. And guess what? It's technically not illegal to make your own weapons, ladies and gentlemen. You can do it. Ancestors have been making their own weapons since the beginning of the country. How do you think they got here in the first place, right? Somebody had to make them. You can still do it. It's not illegal. It just depends on how many you make. You start mass producing them, then you got to start registering and get all those firearm numbers and complying with various firearm acts as well. It is an interesting issue indeed. We'll see what will happen to old Luigi Mangione. Maybe we should do that, Frank. Maybe we should start a, let's see if we can build from a printer here in the office and see how we can do that. Can you look that up, Frank? Seriously, let's see if we can get a 3D printer. Next on the docket, President-elect Trump has been sentenced to nothing. That's right. Donald Trump was given a no penalty sentence in the alleged hush money case Friday by a Manhattan judge, cementing his status as the first convicted felon to become president, but freeing him of the threat of jail or fines as he prepares to return to the White House. Now, probably one of the worst judges in the world, Juan Merchan, to go right along with one of the worst district attorneys in the world, Alvin Bragg. Anyway, Merchan oversaw the trial in which jurors found the former president and future soon-to-be president guilty of concealing a payoff that hid a sex scandal from voters. That's right. What they're doing is saying they took a misdemeanor where the statute of limitations is applied, and they're saying that it was a federal violation of campaign finance laws, and therefore he should be guilty of that. Now, it is interesting that the feds didn't prosecute the federal finance charge because it's not illegal. Hence the reason why this conviction will more than likely be reversed on appeal. Now, the Supreme Court chose not to block it. They basically said there's going to be no penalty, so there's really no harm, so we're not going to block it. Just go through the regular appellate process like everybody else. Personally thought that was a big mistake, but guess what? I guess my opinion will count when I have a seat on the United States Supreme Court, which, although I am a member of the United States Supreme Court there, ladies and gentlemen, they don't ask me what I think. Anyway, we continue. Anyway, Judge Merchan did tell the future president, "I wish you Godspeed as you assume your second term in office." Now, the president-elect, who appeared via video from Palm Beach, Florida, in front of 2 American flags. Now, Trump had faced up to 4 years behind bars on each of the 34 felony counts for falsifying business records. Instead, Merchan's decision means Trump will face no jail time, no probation, no fines, just the title of being convicted. Anyway, the sentence of the 47th Commander-in-Chief gives him a distinction of being the only president ever to be convicted of a felony criminal charge and allows him to finally appeal the guilty verdict he claims stemmed from a political witch hunt. He said, quote, "Today's event was a despicable charade, and now that it's over, we will appeal this hoax, which has no merit, and restore the trust of the Americans in our once great system of justice." The president noted, "Radical Democrats have lost another pathetic, un-American witch hunt." Now, while Trump was forced to sit in court daily for the course of nearly 2 months of trial last year, the president-elect was allowed by Judge Merchan to appear virtually for Friday's hearing. Before the sentence was delivered, Trump, sitting next to his attorneys, Todd Blanche, blasted the case as an injustice and reiterated his claim that he was targeted in a political hit job. "This is a case that should have never been brought," he went on, stating that this was an injustice of justice. "The fact is, I'm totally innocent. I did nothing wrong," as he peered into the camera wearing a dark suit and red tie and his shoulders hunched over. He then ripped the trial as an embarrassment to the state of New York. I would like to explain that I was treated very unfairly, and I thank you very much, he added at the end of his rant. Anyway, the district attorney, the only prosecutor to score a conviction against the former president and future president, an elected Democrat, attended the hearing sitting in the second row. He looked in as a prosecutor by the name of Joshua Steinglass told the court that the verdict in this case was unanimous and decisive and must be respected. Steinglass then blasted the incoming president for using dangerous rhetoric throughout the trial, referencing Trump's threat on the judge and prosecutors. And such threats are designed to have a chilling effect, to intimidate folks, and to have a responsibility to enforce our laws, because they fear he is simply too powerful to be held to the same rules and laws as the rest of us, the prosecutor noted. Put simply, this defendant has caused enduring damage to public perception of the justice system and has placed officers of the court in harm's way. Now, Steinglass added that the probation officer who interviewed Trump before his sentence found that he sees himself above the law and won't accept responsibility for his actions. Before handing the unconditional discharge, the most lenient sentence allowed there in New York, the judge told Trump that his presidential election victory scored him special legal protections that extended well beyond those offered to the average defendant who winds their way through the criminal justice system on a daily basis. Ordinary citizens don't have to receive those legal protections. It is the office of the president that bestows those far-reaching protections to the office holder. Now, the judge also noted it was the citizenry of this nation that recently decided that you should once again receive those benefits of those protections. Merchan also told Trump that even the extraordinary breadth of those protections cannot negate his guilt. One power they do not provide is the power to erase the jury verdict, the judge said. And the sentence came after a year-long trial saga that reached a sensational boiling point when Trump was diverted from the campaign trail to a courtroom in Manhattan. And this was all alleged to the payoff to the porn star Stormy Daniels and a Playboy playmate Karen McDougal to keep them quiet about their alleged tryst. This case also involved Michael Cohen, the convicted perjurer as well. And, well, let's just say it's over, ladies and gentlemen, but it's not over because I do believe it will be appealed. The whole thing is complete. It makes no sense. And let's just be intellectually honest. To take a misdemeanor, turn it into a felony where the statute of limitations has expired, to prosecute a state case on a federal charge because the feds wouldn't take it, doesn't really happen that way. It was a stretch. Paying off people, if you're going to do that, you just do it up front. You don't try to get sneaky with it. Did I think he was involved in all of that? He probably said pay him off, in my opinion. But people do that all the time. People pay people off all the time to go away with their allegations. So, it wasn't about getting a conviction and sending the former, now soon-to-be president to prison. It was a case about getting him off of the campaign trail to give him the title of convicted felon. We'll see down the road, but I think it will be reversed. We'll just have to wait and see. Next on the docket, what do we say about road rage, ladies and gentlemen? Let it go. I get it. It's tough, but I've seen too many cases where somebody on the other side of that road rage has a gun or something worse can happen like this, okay? But the point is, let it go. Don't get out of your car. Don't roll down the window. Drive to the next police station. So this is the moment a Rhode Island woman got body slammed, and she just happens to be a mother of two. She got body slammed to the ground in a road rage incident in Massachusetts. Gladador Kisaya, Kwesiah, we'll just refer to him as the attacker, of Pawtucket, was arrested and charged with assault and battery after slamming Haley Soares of Somerset into the ground after a minor car accident on January 3rd. Now, Soares accidentally hit her attacker's car from behind in Alteboro intersection around 9 a.m., causing the man to get out of the car, bang on Sears' roof, and allegedly drag her out of the vehicle. Soares being body slammed into the ground while struggling to get out of the grip in the middle of the road. Now, the man was seen lifting her little body over his shoulders before slamming her head first into the pavement. Her body then crumpled, and she appeared to, had a little difficulty getting up. She said, by the time I realized I was in the air, I thought to myself, I might die right now. She said it was a very weird sensation that she felt on her face. She realized that she was on the ground and rolled over, and there was blood dripping all over her hands. Now, police found the mother on the ground with blood coming from her head, and she was rushed to the hospital. Now, the attacker was arrested and charged with assault and battery by means of a dangerous weapon, causing serious bodily injury, vandalism to property, and an unlicensed operating of a motor vehicle. You always got to throw that one in there, don't you? You nearly killed a woman. Make sure we charge him with not having a valid license. And then let's set his bond at only $2,500. Yes. Anyway, Haley suffered severe injuries, including a broken knee, a broken foot, damage to her eye socket, and a serious skull injury. It's also revealed that the single mother of two now faces an uphill battle physically, emotionally, and financially. Now, Soares is expected to be out of work for at least the next month while she heals up. Keep those doors locked, ladies and gentlemen. Keep those doors locked in road rage. Don't open the door. Don't talk with them. Drive away. Call the police. Next, a man is not going to be charged for defending himself on the subway. Could there be common sense prevailing in the state of New York that a 69-year-old homeless man stabbed two young thugs who terrorized him on a Queens subway train? And guess what? He killed one and wounded another. Now, in a twist on the transit justice, it's the surviving goons who are now behind bars. The victim was accosted without provocation, and the investigation has shown that he defended himself in an attempt to retrieve his property, the district attorney said. Now, as a result of that conclusion, the district attorney's office will not be filing charges for the fatality. Yes, ladies and gentlemen, finally, common sense prevails. Now, the footage of the incident on the 7 train on December 22nd shows the victim sleeping on the train shortly before 12:30 a.m. when two of the gentlemen, identified as by prosecutors as Stalin Moya and Oswaldo Walter, grab one of the man's bags and take it into a second car. Moya then goes back and grabs more of the victim's bags, walking up to him in the process. Then that's when things get a little crazy. The unidentified victim followed Moya into the second car to try to get his things back, only to be attacked and pounded by several men in that group as they scattered and hid the bags. The footage then shows the victims then being shoved and slugged repeatedly by the group until he had enough and pulls out a long knife and slashes the attacker, wounding at least two. With the slash. Had to pull out the K-bar there. When we talk about the Koberger case, we got to keep it in the sheath because we don't want to offend anybody. Anyway, but that's what you do. With a slash. Remember that. Anyway, the thugs then scattered. One is seen tumbling away there. Look at that, bleeding from his wounds as the victim stands in the middle of the empty subway car clutching the knife. Now, the prosecutor said Moya was killed and the defendant Felipe Peña was wounded. Peña, Walter, and two others, Jose Valencia and Henry Topanto, have been indicted by the grand jury of robbery and assault and charges in the incident. The DF said all of the suspects are also homeless as well. Now, like we talked about, this comes in light of the very recent jump in subway violence there in New York and similarities to earlier instances where people on the subway fought back against their, thugs. Anyway, most notable is the case of Daniel Penny, the former Marine who was acquitted in the chokehold death of Jordan Neely on an incident that took place on the F train back in 2023. We also have the case of Jordan Williams, fatally stabbed an aggressive homeless man who assaulted him and his companion on a Brooklyn J train later that year, but was cleared by the grand jury, and they voted not to indict him on manslaughter and weapons charges. Common sense prevailing, ladies and gentlemen. You don't have to take it, so to speak. Got to have that fear of death or serious bodily injury, but they come at you and there's 2-1. I'm telling you. I think reasonable people will say you acted reasonably, but consult with an attorney in your area just to make sure. Okay? Just generally, that's what I'm saying. Death of fear or bodily injury. Stay at the scene. Don't run away. Call the police. Fear of death or serious bodily injury. Tip of the day. Next, this day in legal history. On January 10th, 1776, the publication of Common Sense by Thomas Paine. That's right, Thomas Paine anonymously published the influential pamphlet of Common Sense, advocating for American independence from British rule. And the pamphlet galvanized public opinion in favor of independence, contributing to the drafting and adoption of the Declaration of Independence, which ultimately led to the Revolutionary War, which led to the United States of America and the Constitution, and here we are today. Next, January 10th, 1861, Florida secedes from the Union. That's right, they became the third state to secede from the United States, joining the Confederacy just prior to the Civil War. And Florida's secession was part of the much broader movement, obviously, that led to the Civil War, challenging the legal framework of the Union and the states. On this day in 1917, the Silent Sentinels begin at their protest at the White House. Now, the Silent Sentinels was a group of suffragists led by Alice Paul, and they began protesting outside the White House for women's voting rights. Their persistent demonstration contributed to the eventual passage of the 19th Amendment. That's right, granting women the right to vote. And on this day in 1967, Edward W. Brooke was sworn in as the United States Senator. Brooke was in Massachusetts, took the seat as the first African-American elected to the United States Senate by popular vote. Obviously, the significant milestone in civil rights history, influencing legislation and the political landscape regarding racial equality. And then on January 10th, 1870, John Davidson Rockefeller incorporated Standard Oil. Now, Rockefeller's corporation would grow to achieve a virtual monopoly over all production in the United States, and Standard Oil's dominance lasted until the corporation was split up into 34 separate companies in 1911 after the Supreme Court found that the company was in violation of the Sherman Antitrust Act, and the rise of the Standard Oil made Rockefeller America's first billionaire and eventually the richest man in the world. Now, the case, New Jersey versus United States, is the case that broke up Standard Oil, was captioned the Standard Oil Company of New Jersey versus the United States, decided in 1910. Now, only one problem with that was breaking it up was that Rockefeller got a piece of all those 34 companies, and he actually made more money. I know there's a lot of stuff said about the guy, but truly, I love watching that show on the History Channel about the men that made America. All those gentlemen that, they weren't looking, they just did it. They just went and did it. It was amazing. And finally, our dumb criminal of the day. Now, before heading off to a drug treatment program on New Year's Eve, Miss Octavia Wells allegedly decided to get a couple of drugs, for the road. So the Floridian texted her a drug dealer that she had $45 to spend and wanted to buy a couple of points, which is a common street slang term for fentanyl. It's about 1/10 of the gram in increments in which they're sold. Anyway, in the text, Wells identified herself as Octavia and arranged the drug transactions. However, after Wells drove to meet the dealer at the Tom Thumb convenience store in Panama City, Florida, she was contacted by the police and arrested. Then Wells realized that she had mistakenly contacted a police officer, not her drug dealer. That's right, Wells had been texting with Stephen Pettijohn, an investigator with the Bay County Sheriff's Office, who is known as PJ. Well, had saved the cop's number under his initials in her phone after a previous interaction with Pettijohn that it is not further described in the affidavit. But anyway, the prior interaction was with the Sheriff's Special Investigation Division, i.e. she was a snitch. Anyway, Wells told the cops that Pettijohn initials were similar to her drug dealers, which caused her to mix them up. Bygones, things happen. Anyway, and they asked Wells to look, says a A cop note allowed her to look at the phone, and it confirmed that the phone was the same one she used to text investigator Pettijohn. A search of Wells' vehicle turned up a variety of drug paraphernalia, and it tested positive for the presence of fentanyl. Anyway, Wells was charged with 1 felony and 2 misdemeanors and booked into the county jail, ultimately paid a $5,000 bond, and was released to return to court again on January 30th. She's been ordered to not possess or consume alcohol and to submit to random UAs as a condition of her treatment. I would say some good mitigation there, ma'am, would be to go to drug treatment so you can tell the judge, this has really been an eye-opening experience and you would like to be clean and sober from here on out. But today, you're a dumb criminal of the day. In fact, you may want to tell the judge, this was so embarrassing. I was found to be the dumb criminal of the day, and that was a huge impact on me because I'm not dumb. Miss Wells, you're not dumb. You're just addicted. So go get the help you need, but still use this badge of honor. Use it for mitigation in your case. All right, everybody, that's all we have for today. Thanks for watching. We'll see you next time on Crime Talk. And remember, the Constitution matters.